Hello, everyone, and welcome to the 7th webinar in our disaster webinar series. Today's webinar is on FEMA recoupments and also fighting disaster CDBG collection lawsuits with Laura Tuggle from Southeast Louisiana Legal Services. Laura has served as the Executive Director of Southeast Louisiana Legal Services since 2014, but she began her career there in the 1990s and has been through many storms, including Hurricane Katrina in 2005, when she was the manager of their housing law unit. I'm Kathy Grunwald, the Disaster Coordinator Attorney at Legal Services of North Florida, and I'm here with my co-host, Carlin Selders, the Disaster Program Assistant at Legal Services of North Florida. As usual, we're recording this webinar, and I'll send you a copy of the recording and the related materials. Will probably be Wednesday of next week. If you have questions during the webinar, put them in the Q&A, and our presenter will answer them time permitting at the end of the first section and then at the end of the webinar. This has been approved for Florida CLE credit. I'll send out that information also with the material, but if you've got a pen and you want to write down the number, it's 2000802N. After the webinar, you'll be asked to complete a short survey on the program, and I hope you'll take a minute to do that. And then I also hope you'll return next week for our final webinar in this series. And so with that introduction, I'm going to turn it over to our speaker today, Laura Tuggle. Thank you, Laura.
Sure. Thank you so much, Kathy and Carlin. Great to see you guys again. And thank you, everyone, for joining this presentation. I will give a little disclaimer at the beginning. Though I was leading our housing efforts after Katrina and many other disasters since then, doing FEMA recoupments and actually doing the collection work and advocacy work on the disaster CDBG has primarily been done by a number of other folks within the organization. But I will go through this material and really try to hit the highlights for you to the maximum extent possible. And I just wanted to give a shout out to our litigation director, David Williams, one of our former disaster attorneys, Rainey Thompson, and our current manager of our public benefits work, as well as a couple of our consumer law attorneys, Jay Abear, Michelle Strauss, and Andrea Jean-Marie, who really all helped put some information together for this. So I think the main thing I wanted to start out with, just in terms of background, I know you guys have been going through a series of really great-looking presentations on various aspects of disaster law and how legal aid responds to disasters. The recoupment piece is obviously at the end, and it's many years later. And so there's a couple of things I just wanted to start out with as we set the stage talking about the recoupment and the disaster CDBG collection actions. So just as background, Katrina hit in the New Orleans area and the rest of the state on August 28, 2005. So it's been over 15 years since that disaster took place. FEMA approved some expedited assistance and also the individuals and household program assistance starting in September of 2005. And then a couple of years later, beginning from 2007 to 2009, is when the state of Louisiana's long-term HUD-funded Disaster Community Development Block Grant funded program for homeowner recovery and rebuilding rolled out. So here we are, pushing 16 years later, after Hurricane Katrina, and over 10 years, or close to 10 years, no, over 10 years, since the disaster CDBG program through what was called the Road Home program in Louisiana, the homeowner rebuilding program, rolled out. And all this time later, we are still getting at Southeast Louisiana Legal Services between 1 to 3 new FEMA recoupment cases that are from Katrina way back when, or the road home collection lawsuits. So when you think about that long time passing, if you're like us, we unfortunately don't have the dedicated disaster staff all the time, though with the way things have been going in terms of significant disasters, we probably should. I mean, Louisiana had 8 hurricanes from late August till just this week, this season alone, the most active season ever. And so while we ended up with a 1-year disaster grant, or maybe if we were really lucky, a 3-year disaster grant, by the time the recoupment cases start, your dedicated disaster staff will probably be long gone, or will have transferred to doing other things potentially within your organization. And so that presents a real challenge when you have these cases coming up and potentially staff that maybe didn't go through the disaster or really weren't familiar with exactly what was happening, the issues that were going on. It's sort of hard to jump into it if you haven't sort of gone through it. But we've done what we can. We're really lucky that a lot of our long-term staff that were around during Katrina are still with us, but many of them are now executive directors, litigation directors, or managing attorneys because so much time has passed. So with that said, I'll kind of jump into the FEMA recoupment a little bit. So one thing I want to say about the FEMA recoupment before we get into that is that if you're in a state like Florida, like Louisiana, Texas, Alabama, Mississippi, if you're in a state that has a lot of hurricanes or floods or other disasters on a frequent basis, something really important to note is that if FEMA alleges that a debt is owed by a client who previously was assisted in a prior disaster, that it does not preclude them from receiving FEMA assistance in a different and new disaster. So just wanted to get that out there at the outset. But even though that is the case, often when these cases present themselves many years after the original disaster, they usually come up in one of 3 ways. There's a new disaster, and somehow this gets brought up in the course of them applying for new assistance. More commonly, though, it presents itself when someone is being approved for something like a Social Security or SSI claim, and they're going to be getting some other kind of federal benefit from another federal agency, and then there is a potential garnishment or reduction in their other federal benefits. The other time they come up a lot is when we have folks that are claiming a tax refund from the IRS, and they get some kind of offset notice saying, you know, you're not going to be able to get all of your refund or part of your refund because you have this FEMA unpaid federal FEMA debt. So one of the big issues that really ties into this whole amount of time that has passed is a lot of times prior FEMA aid recipients and lower income clients, you know, folks are really mobile, they may move frequently, they may have had to move from the disaster, and they don't receive the notices that come out. So FEMA does have a process where we'll send a collection notice and give folks an opportunity to respond to it. And one of the main ways that we're able to still have success in these cases all these years later is if we can show that the recoupment notice the original notice was sent to a stale address or a bad address or some other compelling reason to show that the client never received it. So one thing you may want to do, even as you're talking to clients now, is to screen them to see, do they have any other prior unpaid FEMA debt, because they may not have ever received the notice. So how can you do that? FEMA has a FEMA recoupment helpline. The number is there on the slide, 1-800-816-1122, and they can determine whether any old debt is in collection or not. We haven't had super great luck in getting FEMA to tell us that, even with an authorized representative form. It's usually better for the client to call themselves, or maybe sometimes we can get a three-way call done as well. And so if it turns out that there is an old debt, they can apply for appropriate collection relief. Other options include suspension of the debt. If you're successful on proving or making a strong argument to FEMA's satisfaction that your client never received the notice, then they will kind of start over and reissue the debt collection process, which will in turn stop it will suspend interest and that kind of thing running while there's a decision. So a couple of things, I'm sure you guys in prior sessions have talked about the Disaster Recovery Reform Act of 2018, but that particular act, when it comes to FEMA's authority to recover debts, really mirrors what was done in DARFA. And I don't even know if I can remember what DARFA stands for, but I'm going to give it a try. The Disaster Assistance Recovery Fairness Act, I can't remember now, but it was something that came up in the wake of Katrina for a limited time frame because of high error rates in allocations of funding that led to significant waiver authority, and that ended up almost identically getting picked up in the Disaster Recovery Reform Act of 2018. So the ways that FEMA has the legal authority to waive debt is if the assistance was distributed based on a FEMA error, if it was no fault of the debtor, if the collection of debt is against equity and good conscience and it doesn't involve fraud or some other kind of misrepresentation. The new law requires that the Office of Inspector General monitor FEMA's error rate. In some of the comments to the relatively recent legislation, it was noted that FEMA's error rate is usually about 2%. However, one thing to be aware of is that if FEMA's error rate exceeds 4% for a 12-month period, then this waiver authority can be removed in the future. So that's a little concerning, but so far, to my knowledge, nothing like that has happened yet. And then there is a limitation on the time period from FEMA to try to engage in debt recovery. So FEMA can't recoup if more than 3 years from the date the debtor first received written notice of intent to recoup the assistance, unless there's evidence of civil or criminal fraud. So you may be wondering in your head, if there's this 3-year period of time, then why are we still getting cases from Katrina? A lot of times, this law applies to disasters after, I'm trying to remember now if it's 2012 or, but anyhow, after Katrina. I'm forgetting exactly when that period started. But the other thing is because so many clients, there was some kind of debt notice that was sent out, and either they've forgotten about it or they didn't receive it, and it's only years later when there's a new disaster or when they're trying to to get approved for a tax refund or some other kind of federal money, that they kind of realize, hey, there's this issue that went on, and there was probably some notice sent out years ago, and now it kind of rotates into a different sort of process when there's some kind of federal funds for FEMA to do an offset against. So how is it that FEMA has the authority to engage in even trying to recover the debt? It's because under the regulations, when the person that applies for FEMA assistance at the initial outset, they are agreeing in a certification to repay FEMA from either insurance proceeds or recoveries from another source equivalent to the value of the assistance provided. So also it says that an applicant has to return funds to FEMA and or the state when FEMA or the state determines that it was provided erroneously, spent inappropriately, or if there was alleged fraud. So most of the cases we have don't deal with A, where maybe there was some other kind of recovery from another source and repayment is allegedly due. Almost all of our cases deal with an allegation that the funds were spent inappropriately or provided erroneously. I don't think we've really had anywhere fraud was alleged, or at least kind of when I looked through some of the cases and talked with staff, that's not really what we're seeing as much.
And Laura,
let
me
Sure.
interrupt you for just a second, because I think you
No
just
problem.
answered one of the questions that somebody asked, and now's probably a good time to answer it. Can the speaker provide examples of how a debtor is liable for FEMA recoupment in the first place?
Okay. So some of the cases that we've had, we had a case come in where a lady she lived in a manufactured home, and this one was actually the only one I found recently that was not from Katrina. This is from 2016 floods that we had in the state of Louisiana. And this particular client, FEMA alleged that it was not her primary residence. And so that's what they were claiming, that, hey, you said this was your primary residence, but now we're not so sure that it was. And we think that we paid you these funds in error. So she actually had a manufactured home on land. She did own the land as well. And the manufactured home got significant damage. And she had taken a job where she was temporarily, I think she was on like a 1-year contract, and she was going back and forth between 2 locations. But her permanent residence and the one that she still claimed as her primary residence was the one where the manufactured home had been. And she had used some funds that she got from FEMA to buy a new, to put towards the cost of a new manufactured home. And it was around $13,000 was what she received. And we were able to sort of build the record and show that she had maintained utility service there, that she was paying the taxes, that she was going back and forth. And we made some other arguments, and FEMA decided that she actually was properly entitled to those funds. A couple of other cases that we had, and I think I've got a couple of other examples towards the end of this. I think one of them was a kind of an unusual situation for us, where someone had received there was $2,000 in expedited assistance that was gotten out the door pretty quickly, almost immediately after Katrina happened. And we had a client who received those funds and then ended up going out of the country, actually, for a period of time. I can't remember if she went to school or if it was work related or what, but she was out of the country. We were able to show that through documentation, and that it was a stale address issue where she never received the original collection notice, and then she was able to show that she properly used those funds. It's a little tricky though, because especially if you're needing to provide any kind of documentation of how you spent resources, not too many people keep records this long after the disaster. And I'm talking about these cases I'm talking about right now. One of them came in 2018, 2 others came in 2019. We'll get to that example later in the presentation. But in that particular case, I don't even remember how it came to light that she was allegedly somewhere else, probably just through a review of cases, through some of this monitoring that's going on. So hopefully that answered a little bit, and we'll have another example or two a little bit later. So the collection regulations are here. You guys can read that. There's also something which is still out there. I Googled it to make sure it would still pop up. There's a summary of FEMA's debt resolution process, so that if you get cases like this, you might want to take a look at that. It still pops up when you do a Google search for that. So what can FEMA recoup? They can recoup the expedited assistance if it was approved for a particular disaster. The other needs, personal property program, the personal property program through other needs assistance, transitional housing assistance, rent assistance, transportation, and really any other kind of assistance. So the reasons why, and so this may be getting to that other questions, why would FEMA say you may owe funds? One of the most common ones we have seen is duplication of benefits, which in your FEMA appeals section, I'm sure you already talked about that a lot and the different ways that that pops up. But even all this time later, it can still pop up in the context of an alleged improper assistance being paid. Duplication of benefits for the insurance could be possible, although we really haven't seen that. We have so many clients that unfortunately didn't have flood insurance in many of the disasters we've had. Damaged property not being primary residence, we have seen that. Failure to maintain flood insurance, I really didn't see that in looking through the cases. And then just overpaying for assistance. But the most common ones we've seen is the duplication of benefits for the shared household problem, and then a couple of primary residence issues. So what's the collection process? Well, the first thing that usually happens is FEMA will just send out a notice of debt with a written demand for payment. And then the client has a number of options. If they receive the notice, a lot of our clients don't receive it, but if they receive the notice, they can pay the debt in full, of course. If they say, I really wasn't entitled to this, they can ask for a repayment plan. FEMA will usually give fairly affordable repayment plans. They can ask for a compromise of the debt, and they can ask for an appeal. And, of course, they can't ignore it, which unfortunately a lot of our clients may say, oh, this was years ago, this must be a mistake. And a lot of people, if they did receive it, don't respond. Some of the multiple household claims issues that we've seen, so you guys are probably already very well aware of these things, but the IHP assistance is really meant for one household, and there are so many different ways disasters plays out where households end up being split, or we've had a lot of situations where maybe we had multiple generations of families living in different homes on the same property. That happened a lot. And just different ways that this issue may come up, which I'm sure you guys are all familiar with now. Sometimes family members file multiple applications for the same damaged address, and unfortunately, sometimes folks may engage in identity theft and claim an address when they don't really live there. It could be a family member that's doing that, or it could be a stranger. We've had those kind of situations occur as well. Sometimes FEMA may determine later that they paid out more than they should, and then engage in recoupment action, or they may deny an applicant separate assistance due to another award determination if it's on the same, it's in the same disaster and the same damaged address. So when these notices of debt goes out, there's different deadlines. There's 30 days to pay it in full before interest starts being charged. I don't think we've ever had anybody do that. 60 days is the deadline to file for an appeal, and 90 days is the deadline to set up a repayment plan to avoid financial penalties. The interest is usually about 6% per year. 120 days is the time frame that if there's no appeal request received, or if the appeal is denied, then FEMA can turn a case over to the Department of Treasury for collection action to take place. So the first thing you want to do, unfortunately, we often find that the debt notices may be a little vague and not a whole lot of specific allegations. It may just say something along the lines, we determined that this is an overpayment due to duplication of benefits or something like that, without a whole lot of details. The other problem may be that the client is not going to necessarily remember very much, or may not remember correctly about what was happening during that time, because years have typically passed before these kind of notices even go out. There will be FEMA financial forms and potentially an appeal. And what you will definitely want to do, like you may do with other FEMA appeals, you want to try to see the records. And you can request the FEMA file. The client generally will not have the full FEMA file. They may have some of their own documents if you're lucky, but you can make a request depending upon when the client potentially seeks legal help on a recoupment notice. If they're coming in 45 days and there's only 15 days left for an appeal, you probably won't get the record back even if you request it right away in time for the hearing. So we usually ask for it to be, ask for the record and the appeal around the same time. Usually FEMA will accept our authorization of records form that we kind of have run by them before. Sometimes we have to call and make sure that will be accepted so that we can get the records and see exactly what FEMA is alleging the problem is. You will want the client to review and make whatever you're going to say in response. You want them to say it under oath, or at least declaring that it's accurate. You may potentially need the client's last tax return and proof of attestations about their income, assets, and expenses. Sometimes you may need that because of the FEMA financial form. You can also call the recoupment helpline and get some information. We usually have the client do that or try to do a three-way call with the client. Sometimes FEMA will let us do three-way calls. We used to have no trouble with it. And then sometimes we have a little trouble getting them to allow that. So if, although as I mentioned, this never happens, if you have a client that just says, oh, you know what, I really don't think I was entitled to that, I just want to pay it all back, and I can pay it all back right now, they'll take check, money order, or a credit card. You need to do that within the 30 days to avoid any additional funds being added on. It stops the interest from running, of course. But if you request an appeal, now I don't know that we've ever had anybody do this, but you could pay the debt and still appeal. And if you won, FEMA would pay the money back. We haven't really had anybody with the wherewithal to do that option. Repayment plans are possible, so you could ask for a repayment plan and an appeal at the same time, or a compromise. And that's where that FEMA financial form really comes in, kind of looking at what capacity does your particular client have to pay a debt, what are their expenses, what is their income, is there any kind of debt compromise that can be made. If there is a repayment agreement approved, the installments need to be finished within 3 years, and there's a citation there for the standards for repayment plans. So if FEMA does a compromise, they usually want this in a lump sum instead of in an installment agreement. So there's the standard things here that you would want to show, that there's an inability to pay on the full amount, or that FEMA can't collect on the full amount within a reasonable time, that the cost of collection, like the cost of FEMA having to keep going after these funds, may not justify enforcement. So that may come in if it's like a really small amount, like a $2,000 amount, or some, a smaller amount of money that may not justify the level of the agency's administrative burden in doing the collection. And then if there is significant doubt of the agency's ability to prove its case, they may decide to do some kind of compromise. So the kinds of things that come into that analysis of the client's ability to pay, the age and the health of the client, their present and potential future earnings, inheritance prospects, possibility of concealed or transferred assets, and the availability of assets through enforcement. So you can try to work something out, but it does have to be that lump sum, which is the main thing that you're trying to negotiate there. Suspension of collection can also be allowable if the debtor, and so we usually will ask for the appeal and a suspension of collection activities pending an appeal, even if we're engaging in some of those other strategies. So the debtor has to request waiver or review of the debt. Another thing that comes up is sometimes, what if the debtor can't be located? So FEMA might decide sort of on their own, we're going to suspend collection because we can't find this person anymore. Or if there's an improvement in financial condition expected, but we haven't really argued that before. When can FEMA decide just to terminate trying to collect on the debt? Same thing, if they can't find the debtor, if they determine that the cost of collection to the federal agency will exceed the amount that's potentially recoverable, and if the debt can't be substantiated, is legally without merit, and then I put this in bold, or is discharged in bankruptcy. Or of course, it could be barred by statute of limitations. But the discharge in bankruptcies, these particular debts, as long as there is not an allegation of fraud or misrepresentation, you can discharge them in bankruptcy. And we have had some clients that, after hearing different options, have gone that route. Termination, though, only ceases active collection. Of course, if it's discharged in bankruptcy, that may be a little bit different situation. A couple of other things you may want to think about, which I mentioned, I think, before. Your resolution may not come before the 60-day debt notice appeal deadline, so you may want to have the client exercise other options in the meantime. Maybe they pay if they can, maybe they start a repayment agreement and hope for a different outcome. An actual discharge or compromise of the debt may result in an IRS Form 1099 issuance. So potentially there might be some tax liability. If you win the appeal, FEMA will return any money that's already been paid while that process was ongoing. So a little bit about the appeal process. So the appeal is usually on paper, but you can ask for an oral hearing. and you can explain why you need it. And if FEMA agrees that this is necessary, it could be by telephone. Technically, it could be in person, but that's not going to happen. But it could feasibly be by telephone. When you really may want to ask for that, especially if there's credibility issues involved, if there's not a lot of details, or you don't think there's sufficient details to substantiate the debt. Our staff tells me that FEMA is unlikely to grant an oral hearing, so you really have to make your case for it really strong, probably submit stuff, with an affidavit from the client, at least an unsworn affidavit, but even better if you can do a sworn affidavit, notarized, and then trying to remember to preserve evidence is really important. That's a really tricky thing. So as you're talking with your clients now that are going through disasters, that you may be actively assisting, letting them know how long they really need to hold on to records is really important, because this could be many, many years later that something like this could come up. So try to submit competent evidence, in case there's an appeal. And we often reserve our right to supplement the appeal in case we get some kind of new evidence, like the FEMA file comes in after the appeal deadline or the client produces some information. We usually write that in our request for appeal. Some other issues with appeals, FEMA may revisit issues that you believe or the client believes have already been favorably resolved in the initial application process, or potentially bring up something entirely new that kind of comes as a surprise to you when you're going through the appeal process. The most common issues addressed that I talked about in the beginning that can kind of lead to a debt notice going out, we mentioned that, but there could also be issues about mistaken valuation, or misuse, allegations of not using the funds appropriately. You can always argue other compelling factors, such as a need for an accommodation for someone that may be living with a disability. You could argue res judicata, equitable estoppel, and some other kind of hardship by this collection action. You do have a right to judicial review for up to 6 years after the first FEMA appeal on the particular issue. You have to have timely appealed. I don't really think we've ever done any judicial review requests on a recoupment. We've had a couple on other issues for other kinds of FEMA appeals. So step 2, after you get through that debt collection notice, and I'm looking at my time, I think I got another 7 minutes or so on this part. On the FEMA step 2, after the debt collection notice, once whatever happens with that, it wasn't responded to, or it was an appeal, or whatever happens, the next thing is if there's not an undoing of the collection notice through an appeal, would be a letter of intent that comes from the FEMA Financial Center, and it'll be like a last chance sort of notice to pay or resolve the debt. And then after that, if there's no action from the client after receiving that, then the debt will get referred over to the United States Department of the Treasury, which will then send a notice explaining their different ways that they can collect. And the main way is offsetting other federal payments, like Social Security benefits or SSI tax refunds. That's the most common way that they're presenting themselves as they're coming to us years later. There could be a referral to a private collection agency, and if someone is a federal employee, there could be an administrative wage garnishment. So if FEMA decides to proceed with the collection, certain things are protected from recovery. So this is very much like getting sort of into consumer law. The debtor's first $750 a month in Social Security income is exempt from federal debt collection. and the collection is in general limited to about 15% of the particular client's income. If it's in a court action, exemptions are available that typically would be available the same way as they are in bankruptcy, and that citation there for what you would look at. Some other resources are here. You guys probably know all about these potential resources from having gone through this before. So all these years later, can you still get relief for your clients? If it's been 3 years, if it's been 5, if it's been more than 15, actually you can. It gets harder and harder as more time passes because it just gets more difficult to kind of put your case together for your client to pull records or to just remember what happened. So the main way that you can still get relief is if you can show that that original debt notice went to a bad address. We've had pretty good results in identity theft cases where someone else claims that they're or uses an address that maybe didn't live there. We've had pretty good outcomes with those, and for other kind of equity issues based on the client's current inability to repay the funds based on their financial circumstances. So one example is JV. This is the person I mentioned earlier with the expedited assistance. She was out of the country when the notice came out. We submitted proof through her passport and visa, and the debt was disputed. There was also a shared household issue in this case, and we ended up winning that case in 2019. It came in October of 2018, and it was from Katrina, so it was many, many years later. Then we had OW. He had a $3,000 alleged overpayment from Katrina. He was adamant that he never received the notice. He contacted us in February of 2019. As we were interviewing him, it came out that he doesn't really read or write very well, so he might have received that notice potentially. But he was positive that he never got those funds. We thought that there was possible identity theft of like someone that was handling his business for him, who kind of mishandled it, and staff were able to show to FEMA's satisfaction that actually was the case, and FEMA ended up canceling the debt. And he was really worried because his SSI was going to get garnished, a certain amount of it, and he really needed those funds to be able to afford his expenses. And then we had PW. This is the lady with the $13,000 alleged overpayment. This is the only one I could find with a recent positive outcome, not from Katrina. She was from the 2016 flood. The only other thing I'll mention here is that she did contact us in September of 2019. The issue was that primary residence issue, and we resolved that case at some point in early 2020, I think right before COVID, and so that debt was canceled. So even after tons of time, you can still win these cases, but it gets tougher. I'm going to spend the... Yes, go ahead.
Before you go on, let me ask you a few questions that came in
Sure.
on his part. The first one, will a FEMA debt show up on a credit report?
Yes.
Okay.
It will.
And the second one, to get the waiver, must all of the factors be present? So for example, if there's error on the part of FEMA, but must there also be no fault on the part of the individual?
Yes.
Okay.
Yes, all the factors present.
Okay. Have you seen any successful untimely appeals waivers granted? Somebody had filed one past the 60-90 days.
That one, I think the answer is yes, but I would have to double check with staff, and I will give you an email address to double check on that, and maybe I could even figure out how to put it in the chat. If I don't know, maybe I can't.
I think I can. I'll do it. I'll do it.
It's rjones@sLLS.org. Rowena Jones. She's the head of our Employment and Benefits unit, and their unit is handling all of these at this juncture.
Okay. Let's see. How many FEMA overpayments are you all seeing in your office, or have you that have been coming into your office? Do you have an?
About 1 to 3 a month, still.
Okay. Yeah, that's
all this
crazy.
time later. It's kind of unbelievable. But I'm talking about, so I'm going to modify that answer, because when I pulled the records, the 1 to 3 also includes these disaster CDBG collection suits. So, you know, one month we might get 1 FEMA recoupment and 2 collection suits. 1 month we might get 3, you know, but the point is these cases are still coming in. They were hot and heavy, like around 2012 when DARPA came. We were getting tons and tons and tons of these things. Now it's whittled down to where it's a little more manageable.
Okay. Somebody's asking, have you heard of, or is there a possibility of a recoupment moratorium possibly associated with COVID-19?
Haven't heard of it, but that would be awesome. Now they may be, you know, it wouldn't surprise me if there is a little more leniency because of COVID-19 and maybe some kind of suspension, but I haven't specifically heard that one yet.
Okay, and finally, somebody asks, can SSI, not just SSDI, be recouped?
Yeah, I think so. And this gentleman, the one example I just gave, he was on SSI and got one of those notices.
Okay, all right.
The offset notice from the Treasury Department. Okay, great.
Thank you.
So, thank you. So for the last 13, 14 minutes, I'm going to try to talk to you guys about something that I never handled myself. And my background is housing, not consumer. But when you get into the disaster community development block grant reimbursement suits or collection suits, you're pretty much coming over to the world of almost all consumer law, and so that's a little bit different too, where you really got to lean on some folks with that consumer knowledge to kind of come in and help out a little bit. But just by way of background, our Louisiana Road Home program, which was the big homeowner rebuilding program for long-term recovery for homeowners, came from HUD disaster CDBG funds. That's still a pretty common method of getting the long-term recovery funds out there. These funds were administered by the state of Louisiana through their disaster recovery unit. And HUD at some point was requiring the state to seek recovery for alleged improper or fraudulently received road home funds. So basically, when these funds came down, homeowners would, let me just check one thing here. Yeah, I'm going to tell you that because I think I put it in the notes. So homeowners in Louisiana received, I think that almost 10 billion. I think it was like 9.7 million or billion. I've got it in here somewhere. But a huge amount of resources came down, and there were different OIG reviews and a lot of monitoring, and so HUD got concerned that the state didn't necessarily have as much backup as they wanted to see to ensure that the funds were appropriately used by homeowners. And homeowners, when they got these funds, they had to sign these covenants, and then those covenants were recorded against the property. And there were various conditions about how you were supposed to use the funds, and there was usually a 3-year period for the homeowner to get back into homes if they exercised what we called option 1, which was basically the funds to repair your home and get back into it. There was the possibility of extending that period of time for compliance to 4 years if you need a little more time. And so we really didn't see any big push for compliance monitoring of how homeowners use those disaster CDBG funds until at some point in 2013. So that would have been about 5 years after Katrina, past some of the earliest homeowners that got funding. Those awards didn't start going out till 2007. So it was right about 5.5 years when a big bunch of letters went out. About 55,000 letters went out, actually really close in time to the anniversary of Katrina. And families were sent out different compliance questionnaires. They were asked about certain things, and they were asked to submit certain documents. So there were different funds that went out. There was some money to repair homes. There was some money to elevate homes, and there was another bucket of money called the Hazard Mitigation Program, which really was for things like raising your central air and heat system up off the ground so it wouldn't get flooded, storm shutters, those other kind of mitigation measures. And so when these letters went out, the state was looking for elevation certificates, having the forms filled out that they were requesting, utility bills. They wanted to see if people were living back in the properties, a homeowner's insurance declaration page, and flood insurance, because families were required to maintain insurance on their homes as part of their covenant agreements. And they really, if funds were used to elevate homes, they wanted to see those elevation certificates. There are different kinds of noncompliance reasons for road home grants. One potential noncompliance that could lead to collection action. This was the first thing that happened before lawsuits were filed. The applicant and/or a co-applicant, if they just didn't respond to the compliance letter, that potentially could trigger other action being taken against them. If they were non-compliant, like something wasn't submitted, like we gave you an elevation grant and you didn't provide the certificate, that could be a problem too. And then on the hazard mitigation grant program, was there some documentation not received for that particular program? So one good thing that ended up happening with these potential monitoring and compliance notices and sort of ramping up to potential collection is that HUD has something called unmet needs in their guidance. They have a big document about unmet needs, and some of our clients ended up, even though they were pending collection or potentially got sued, they were able to, once they got to us, sometimes we were able to claim that they qualified for unmet need and that they should, in fact, get additional funding and not potentially have to repay funding. So there is in these guidance documents an acknowledgement that things change over time. And so some of the main reasons, if you can demonstrate a change in circumstances, you can qualify for additional funding. So it could be contractor fraud. You got these funds, you paid somebody to do this work, and they ran off with the money. Another thing could be if you can demonstrate that there's been an increase in the cost of materials or labor from the time the award came down to the time you were able to do the work. Changes in zoning or building codes that may have made you have to do something a little different or a little more costly, or if you've had subsequent damage, usually from another disaster, to your home, and maybe you had already started fixing it, and then another disaster came along. That actually happened, unfortunately, not too uncommon in Louisiana, because Katrina came, and then right behind that there was Rita, and then we've had Isaac and Gustav, and 2016 floods, and some tornadoes, and some other things. So that has actually happened in some cases. And then the state reevaluating the calculation of the award because of other kinds of needs. So sometimes the unmet needs really helped our clients potentially get more resources. And there's a link there to the Road Home site where it talks a little bit more about this compliant process and how they determine unmet needs. Though HUD issued this guidance, our advocate community really fought hard for policy changes, and they were actually successfully able to get the state to put aside some of their unspent road home funds to actually pay nonprofits to work with families to try to help them resolve these compliance issues. So they actually paid case managers, not through the state, because there were some trust issues there, and they actually made some grants to local nonprofits in trying to help them work through some of these issues, and a lot of families ended up getting more rebuilding funds as a result of this process. I'm going to kind of jump through this. This is just more stuff from the unmet needs definition. So some things that, if you have a client that comes to you, if there's a process like this that happens in your state or with some disasters later after the disaster, if clients come to you when they've received a monitoring letter, you may be able to help them respond to it in a way that could prevent some very distressing, lawsuit being filed, or maybe even help them claim additional funds under the unmet need criteria. If that's not really, if none of those things really seem to work, you can also try to work with your clients on setting up a more affordable repayment options if you can't show that they actually complied or if there's an unmet need. So we've had a number of cases where folks just didn't respond to the letters, but they actually had the documents, and those are usually, pretty easy to resolve, no matter if you're actually in collection or sort of at that pre-collection stage. One thing to mention, the Road Home program through the state of Louisiana, they don't really want to foreclose on properties. Even if they are successful in taking a lawsuit all the way to the point where they get a judgment and they end up filing a lien against the property, they're pretty much not going to foreclose. And part of the reason for that is, they have to show that they're taking action and attempts to try to recover these debts, but they don't want to become responsible for maintaining and taking care of even more property. The state ended up doing some buyouts and things like that. They were having to spend a fortune even on just cutting the grass and those kind of things. And so that's really not something that they want to take more on. I don't know if they've publicly said that, but that's sort of part of what's going on in the background. So I'm super close to my time. So what are the options if a homeowner is alleged not to have properly used this disaster CDBG funds? You want to be sure that under state law, if they get sued, that they need to timely file responsive pleadings, motion for extension of time, maybe an answer, and then you're going to try to evaluate the merit to the best of your ability. And so some of the things, because you're getting usually a third-party private attorney, a debt collection attorney is usually working under the contract with the state once it gets to the lawsuit stage. And so you can look at whether a 30-day validation period was done for the debt under the Fair Debt Collection Practices Act. You can determine, hey, is the client actually out of compliance with whatever the rebuilding criteria was? Those kind of things. Was there an unmet need? Do they need more time to comply, that kind of thing? Do they actually get the money? Most of the time our clients have, but we had a few situations where somebody's mortgage company made them pay off the mortgage balance. And we've had a couple like that. Then if the road home program is now claiming, hey, you were never really eligible, should they be allowed to revisit that prior judgment call that they made if there's not an allegation of fraud? Was the road home covenant properly secured? Was it properly filed? Is there some other co-owner or heir that maybe didn't sign on to this thing? Has the alleged debtor responded to their letters giving reasons why they need more time or why they should be given a hardship? Sometimes that's something that you can do. Are there facts that would shock the conscience in the case? And then one that we do explore and we have utilized several times, would a Chapter 13 or a Chapter 7, if the home equity is less than our state's allowed homestead exemption, is this a route to try to resolve the debt? So I think we've run out of time. I've got 2 more slides, so I don't know if I have time to go through them. You'll have to tell me, Kathy.
You do. Yeah.
Okay, great. So some other things to keep in mind if you get to this point where your client is sued. So some homeowners are just going to want to say, you know what, I got this money and I didn't use it for what I was supposed to use it, or maybe I only used part of it for what I was supposed to use it. I'm just going to enter in a repayment agreement. You could do that, and we have had some clients that have done that. And have gotten agreements of about $100 a month. The only problem is you have to repay it within 5 years. So if it's a big amount of money, there might be this big balloon payment on the end. And I mentioned that they don't really plan to foreclose on the properties, but I don't know if that's said publicly. We've had some homeowners who'll just say, you know what, I don't want to deal with all of this. I'm just going to let them take a judgment and put a lien on the property, and then when I pass away, you know, I'm just going to let my heirs figure it out. I think a lot of it depends on how much debt we're talking about. If it's only a $7,500 hazard mitigation grant, that's a little easier to deal with. The average road home grant, I think, was around $69,000, and the average elevation grant, the max was $30,000. And most of the cases that we are seeing are from people who got $30,000 for elevation grants and did not elevate. And one of the main reasons why they did not elevate is because $30,000 simply wasn't enough to cover the cost of elevation. It could be anywhere from probably $70,000 to $100,000 to actually do an elevation, especially if you had a home that was like on a brick slab on a foundation. And so that has been probably the most problematic that we've seen. And we have successfully been able to get some clients more funds when we've been able to show, hey, they didn't use it to elevate, but they did use it to fix their house. Or other kinds of rebuilding. So we've had some success with that as a advocacy tool. So I'm going to stop because it is stopping time. Do you have any more questions, Kathy? I'll do my best, although this last part is not work I've actually done myself.
No more questions today. So thank you very much,
Sure.
Laura, for presenting. We got a lot of really helpful information. Hurricane Michael survivors are waiting for the CDBG money. Some Hurricane Irma survivors have received that money. So the information we got in the last part of it, we may be able to use down the road, but maybe not because we won't need it.
Keep your receipts, keep your documents. I mean, it's insane. It's a bit distressing and kind of mind-blowing that this much time could pass and you're still dealing with this.
Yeah, that is crazy.
You just can't get rid of your stuff ever.
That is crazy. But thank you for presenting, and thank you everyone for listening in today. Come back next Thursday at noon for the last webinar in our webinar series with Linda Anderson Stanley on disaster legal hotlines. So thank you very
Awesome.
much, and we'll close it
Thank
out
you.
today. Bye, everybody.
Thank you.